Mr. Craven, are you and Mr. Maddox ready to proceed?
We are, Your Honor.
Is the government ready?
Yes, Your Honor.
This time I'd ask that Mr. Maddox be sworn or affirmed.
Please place your left hand on the Bible and raise your right hand and state your name for the record.
Eddie Normal.
Do you swear that the answers you will make to the court are true to the best of your knowledge and understanding, so help you God?
Yeah.
Mr. Maddox, do you understand that having been sworn that your answers to my questions are subject to the penalty of perjury, and if you were to lie to me, you could be prosecuted for perjury or for making a false statement?
Yes, sir.
Have you taken any kind of medicine or other substance in the last 48 hours that would affect your ability to hear and understand these proceedings?
No, sir.
Do you know why you're here today?
Yes, sir.
Mr. Craven, do you have any reason to doubt Mr. Maddox's competence to go forward today?
No, sir, I don't.
Does the government have any reason to doubt Mr. Maddox's competence to go forward today?
No, Your Honor.
Based on Mr. Maddox's answers to my questions, my observations of Mr. Maddox and the answers from counsel, I find that he is competent to go forward here today. Mr. Maddox, you're here today having entered a plea of guilty to 2 charges. The first charge is conspiracy to distribute and possess with intent to distribute 28 grams or more of cocaine base. The second charge is possession of a firearm and furtherance of a drug trafficking crime as set forth in count 6. In light of some cases from the Supreme Court of the United States, including the Booker, Rita, Gall, Kimbrough, Spears, and Nelson cases, the sentencing guidelines are no longer mandatory, they're advisory. Nevertheless, in accordance with those cases and numerous cases from the Fourth Circuit interpreting them, including the Carter, Pauley, and Evans cases, a sentencing court still must take into account the now advisory guidelines. The court does this by initially making findings of fact and calculating an advisory guideline range. I'll then consider any motion that might be made that might move the range either up or down. I'll consider all arguments that your lawyer makes here on your behalf, any statement you'd like to make, and all arguments of the Assistant United States Attorney. I'll then determine your sentence and announce it here in court today. That'll be the process we'll follow. Mr. Craven, did you receive a copy of the pre-sentence report?
Yes, Your Honor, we did.
And Mr. Maddox, did you receive a copy of that report, sir?
Yes, sir.
This time, the court directs that the pre-sentence report be placed in the record under seal. In accordance with Rule 32 of the Federal Rules of Criminal Procedure, the court accepts as accurate the pre-sentence report, except as to matters in dispute as set forth in the addendum. The addendum does contain 2 objections, one by the defense, one by the government. Does the defense want to be heard on the objection, which does not appear to affect the guideline range?
Your Honor, we withdraw that objection
Okay.
and do not wish to be heard.
Okay. Does the government want to put on any evidence in connection with its objection?
No, Your Honor, we are withdrawing that objection as well, Your Honor.
Okay. All right, so there's no objections to the report from the government?
Correct, Your Honor.
No objections to the report from the defense?
Correct, Your Honor.
Is that correct, Mr. Maddox?
Yes, sir.
All right, for purposes of Booker and its progeny, then, the total offense level is 21, the criminal history category is 3, the advisory guideline range on count 1 is 60 months, the advisory guideline range on count 6 is 60 months consecutive. Does the government object to that advisory guideline range?
No, Your Honor.
Does the defense object to that advisory guideline range?
No, Your Honor.
All right. At this time, I'll hear first from Mr. Craven. I'll then hear from Mr. Maddox. I'll then hear from Mr. Gray. Mr. Craven.
Thank you, Your Honor. Judge, because of the statutory penalties in this case sort of encompassing the guidelines, I would ask that Your Honor impose a sentence of 60 months on each count. And also for that reason, I'll be brief today. Mr. Maddox has been a very reasonable client to represent. He's been straightforward and honest with me from day one. He's never backed away from responsibility. He's never nitpicked unnecessary details. He gets it. He understands the wrongfulness of his actions and why he's here. In meeting with him, Mr. Maddox, and given the way he's presented himself to me, I just can't help but think that he has so much more to offer to himself, to his family, to the community, and I really hope he does that in the future. He's repeatedly pledged to me to retire from street crime and live a good and respectable life. He's got family here in the courtroom. I know his mother and brother are here. I have talked to his mother countless times on the phone. She is a very strong woman, very much a positive influence on Mr. Maddox, and I know she's committed to helping Mr. Maddox. Mr. Maddox's brother was also a veteran of the federal system. He has completed supervised release, and I think really has demonstrated to Anthony here that you can do life the right way. You can leave this behind you and do the right thing, and that's what I hope and think and have every reason to believe that Mr. Maddox will do in the future.
What's the status of the pending charges in paragraphs 34, 35, and 36?
Your Honor, my understanding is that they're still pending. There is some hope that those will be dismissed. Your Honor, if Your Honor would recommend Mr. Maddox for drug treatment and also for vocational training in the BOP, and if Your Honor would also please consider recommending him to FCI Bennettsville, South Carolina. Thank you.
All right, Mr. Maddox, would you like to make a statement, sir? You may.
No, sir.
Okay. Mr. Gray?
Thank you, Your Honor. And in light of the statutory requirements, we also asking for a sentence of 120 months. However, we believe that this is an appropriate sentence based on the factors under 3553A. When we take a look at this defendant's overall history, one thing that jumped out at me immediately when reviewing the PSR is that he has 3 children, and his youngest child is, his oldest child is 13 years, which is the exact same amount of time that this defendant has been engaging in a continuing course of criminal conduct. His entire history since the age of 18 has unfortunately been one run-in with the law after one run-in with the law, with another run-in with the law, involving drugs, involving, as the pending charges show, violence. This is someone who 120 months hopefully will help serve that deterrence purpose. Unfortunately, when you also take a look at this defendant, you realize that he's a person who had a lot of opportunities. He had a caring parent. He had a loving mother who's here to support him here today. He's had the opportunity to be better. However, unfortunately, when we look at his overall history, we see someone who, when given time and time again an opportunity to correct his behavior, he has not. We are looking and hoping that in this case, 120 months will provide that deterrence, will provide that safety for the community, and will ultimately get him to change his ways, as Mr. Craven has indicated he is hoping to do. Thank you, Your Honor.
Thank you, Mr. Gray. All right, Mr. Maddox. The court recognizes its obligation to impose a sentence sufficient but not greater than necessary to comply with the purposes set forth in the statute. I have considered all arguments that Mr. Craven has made on your behalf. I have considered the position of the United States. I have considered the advisory guideline range. Among other things, I'm to consider the nature and circumstances of the offense and the history and characteristics of the defendant, the need for the sentence imposed to reflect the seriousness of the offense, to promote respect for the law, and to provide just punishment, the need for the sentence imposed to deter others who might choose to engage in the criminal behavior that brings you here, the need for the sentence imposed to protect the public from further crime by you, the need for the sentence imposed to provide you with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. The statute lists numerous other factors. I've considered all those factors, although I won't mention each one individually. As for the nature and circumstances of the offense, you did participate in a conspiracy to distribute and possess with intent to distribute 28 grams or more of cocaine base. The conspiracy took place during 2015. You also possessed a firearm in furtherance of a drug trafficking crime as reflected in count 6. Both of these are serious offenses. The report indicates that you were a member of the eight Trey Crips, a criminal street gang that obviously makes money illegally. You obviously were somebody who was making money by being a drug dealer, which is not a good way to make a living. You do have 3 children who certainly deserve a much better example than you've provided them so far in their life. I mean, surely you have to be rational and not say, I hope my children grow up to be drug dealers. I hope my children grow up to be gangbangers. What parent would want that for a child? no parent that's rational, and yet any rational human being should know that your children watch what you do more than they listen to what you say. And if they see that my dad's a gang-banging, drug dealer, gun-toting guy, what are they going to learn? And as Mr. Craven said, and as Mr. Gray said, the shame of all of this is that your mother has provided a lot better example than you've lived up to. Because I can tell you, when she held you in the hospital when you were born, she didn't say, I can't wait to watch him go to prison for being a drug dealer. And I know throughout your life, she has told you, this is not right. And yet, she can only hope for you. She can't choose for you. And this is the choice, this criminal lifestyle. So Mr. Craven, he's a good lawyer. At the end of the day, you're going to have these opportunities in the BOP to actually improve your life. If you go back to the same people in the same places, in the same lifestyle, the report indicates you've been smoking marijuana every day since you were a teenager. How's that been working out for you? If you go back to that, you'll come back here and you'll go to prison and you'll get a longer sentence than you're getting today. I will impose a sentence that will provide, I think, adequate incapacitation, which is one of the factors I'm to consider. It will provide just punishment. It will provide general deterrence. Having fully considered the entire record in the case, it's a judgment of the court that the defendant, Anthony Bernard Maddox, is hereby committed to the custody Bureau of Prisons to be in prison for 60 months on count 1 and 60 months on count 6 to be served consecutively, producing a total term of 120 months. Pursuant to the plea agreement, counts 2, 3, 4, 5, and 7 are dismissed. You'll be placed on supervised release for 5 years. This term consists of 5 years on count 1 and 5 years on count 6 to run concurrently. You'll comply with the standard conditions as well as the following additional conditions. You'll participate in a narcotic addiction treatment program. You'll consent to a warrantless search. You'll cooperate in the collection of DNA. You'll support your dependents. You will have a job while you're incarcerated. Your children at least deserve that you send money home to help them. I'm not going to impose a fine. You'll pay a special assessment of $200. I do think I've properly calculated the advisory guideline range in this case, but I announced pursuant to U.S. v. Gomez Jimenez 750 F. 3rd 370 4th Circuit 2014 and U.S. v. Hargrove 701 F. 3rd 156 4th Circuit 2012 that I'd impose the same sentence as an alternative variant sentence if I have miscalculated the advisory guideline range. In accordance with Mr. Craven's requests, I recommend intensive substance abuse treatment. I recommend vocational educational work opportunities for Mr. Maddox so that he can improve his skills. I recommend that he serve his sentence at FCI Bennettsville so that his family can be part of his life. Mr. Maddox, you can appeal your conviction if you believe your guilty plea was somehow unlawful or involuntary, if there's some other fundamental defect in the proceeding that was not waived by your guilty plea. You also have a statutory right to appeal your sentence under certain circumstances, particularly if you think your sentence is contrary to law. However, you did enter into a plea agreement that contains an appellate waiver. In light of your sentence, I believe you've waived your right to appeal your sentence. If you believe the waiver is unenforceable or inapplicable for any reason, you can present that theory to the appellate court. With few exceptions, any notice of appeal must be filed within 14 days of the judgment being entered on the docket in your case. If you're unable to pay the cost of an appeal, you may apply for leave to appeal in form of pauperous. If you so request, the clerk of court will prepare and file a notice of appeal on your behalf. Mr. Craven, I think I made all the recommendations that you asked for on behalf of Mr. Maddox. Is there anything else today in Mr. Maddox's case?
No, Your Honor. Thank you.
Anything else from the government?
No, Your Honor, thank
I
you.
thank counsel for their work here today. That'll include the matter of Mr. Maddox. Good luck to you, sir. We'll be in recess until 1.